Cut. Good morning, all friends. Welcome to our YouTube channel. This is developed by concept developed by Advocate Madhuri and supported by Advocate Mahesh Developper, Advocate Vishal Tippe, Mr. Vishwajit Lal, Rajesh Pawar, and Advocate Dhananjay Deshmukh. We are now seeing the Indian Evidence Act, MCQ, multiple choice question, and important parts. Part first, Section 3 of Interpretation Clause. Court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence. Facts will include 1. Anything, state of things or relation of things capable of being perceived by the sense. Second, any mental condition of which any person is conscious. Relevant. One fact is said to be relevant, another when the one is connected with the other in any of the ways referred to in the provision of this Act relating to the relevancy of fact. Fact in issue. The expression fact in issue means and includes any fact from which either by itself or in connection with other facts the existence, non-existent nature or extent of any right, liability or disability ascertained or denied in any suit or proceeding necessary follows. Evidence means and includes first, all statement which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. All documents in bracket including electronic records produced for the inspection of the court. Such documents are called documentary evidence. Proved. A fact is said to be proved when, after considering the matters before it, the court earlier believes that it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. Now we see the disprove. A fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. Not proved. If a fact is said not to be proved when it is neither proved or nor disproved. India means the territory of India excluding the state of Jammu Kashmir. MCQ multiple choice question under section 9 of Evidence Acts uh, D, both A and B are relevant. The section 9 of Evidence Act, the identification periods of suspects are relevant. The identification periods of cattle are relevant. Second, another question. Secondary evidence of document means both A and B. A. Oral account of the contents of documents and copies of that document. Period of 30 years under section 90 of Evidence Act to be reckoned from the date on which the document is tendered in the evidence and when its genuineness becomes a subject of proof. Section 92 of Evidence Act is applicable to disputes between the parties to the instrument only. Mode of proof of custom is contained in all of the above. Section 48 mode of proof of a custom is contained. Section 48 of Evidence Act, Section 37, Section 32, 7 of Evidence Act, Section 32, bracket with 4 of Evidence Act, admissions either oral or in writing. We see here explanation. Section 17 admission defined as admission is a statement, oral or documentary in bracket or contained in electronic form bracket which suggests any inference as to any of the person and under the circumstances here in after mentioned. A confession made by a person while in police custody is inadmissible as per section 26 of the Evidence Act. Okay, bracket. Section 26 of confession by accused while in custody of police not be proved against him. Section 27 of Evidence Act applies when the person giving information is an accused and in police custody. A dying declaration to be admissible may be made either before a magistrate or a police officer or a doctor or a private witness. Opinion of experts are relevant under Section 45. Explanation. Section 45. Opinions of expert when the court has to form an opinion upon a point of foreign law or of science or art or as to identify of handwriting or finger impression the opinion about that point of person specially skilled in such foreign law, science or art or in question as to identify of handwriting or finger impressions are relevant facts. Burden of proof means D. Both and E. Both A and B. both A and B बरोबर है. Burden of proof means the burden of proof as a introduction of evidence. The burden of proof means the burden of proof as a matter of law pleading is burden of establishing case. The doctrine of estoppel is a rule of evidence. It is very important. Estoppel. What is estoppel? When person has by his declaration, act or omission intentionally caused or permitted another person nor his representative shall be allowed in any suit or proceeding between himself and such other or his representative to deny the truth of that thing. For presumption under section 107 of the Evidence Act, the person is to be shown to be alive within 30 years. Section description. Section 107 burden of proving death of a person known to have been alive within 30 years when the question is whether a man is alive or dead and it is shown that he was alive within 30 years, the burden of proving that he is dead on the person who affirms it. An accomplice is competent witness under section 133. Section 133 accomplice shall be competent witness against an accused person and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of a accomplice. For presumption of death under section 108 of evidence, the person is shown to be not heard for the period of 7 years. Explanation. Section 108 burden of proving that a person is alive who has not been heard of for 7 years dash, provided that when the question is whether a man is alive or dead and it is proved that he has not been heard of for 7 years by those who would naturally have heard of for 7 years by those who would naturally have heard of him if he had been alive. The burden of proving that he is alive is shifted to the person who affirms it. Section 118. Who amongst the following are competent witness? All the above means lunatic, child, accused. Examination by the party calling the witness. Examination in chief. Question. Re-examination of witness shall be by the party calling the witness. Leading question be asked during the cross-examination. The provision of hostile witness is provided in section 144. Policy in INO, policy in omnibus is. Cut the question. And identification of a suspect by photo is admissible in evidence. Admission has been defined as a statement made party or any person connected with him suggesting inference as to a fact in issue or relevant fact certain circumstances under section 17. Confession made by accused while in police custody. Is admissible under section 26 of Evidence Act if made in the presence of magistrate. Section 27 under section 27 of Evidence Act. Here is the answer is D, only A, not B. Means under section 27 of Evidence Act, the whole statement is admissible. Declaration in the course of business are admissible. D, section 32 bracket मध्ये 2. The court may in its discretion call for proving the facts which have been admitted otherwise than such admission. Under section 45 of the Evidence Act, the opinion of expert can be for D, both A and B. Identifier of finger impression, identifier have handwriting. Section 79 of Evidence Act applies to answer is D, all the above. Means certified copy issued by a government officer, certified issued by a government officer, the other document duly certified to genuine by a government officer. Secondary evidence of a document is admissible as substitute for admissible primary evidence. Section 90 of Evidence Act applies to both testimony and non-testimony documents. Section 92 of Evidence Act applies to bilateral documents. 108 of Evidence Act relates to presumption of death. Burden of proof is lightened by all the above. Here we stop. We see the part second of Evidence Act. Next part, I advise you that you should listen a lot and read a lot for MCQ, and there is a 100 marks question paper for MCQ, multiple choice of question, and evidence is the important law when you going to become a practice in the court or also doing the job anywhere. Evidence is the backbone of the law. It is applicable to all courts, civil, criminal, and other courts. Thank you for watching, and once again I am thank you for watching our channel, and you always give new thing in every 3 or 4 days. Advocate Madhuri Lawan and Advocate Mahesh are preparing these notes for you. Take the benefit of it. If any doubt, you email on us. Okay, thank you. Read a lot and listen a lot.